Three. This is the concurrent list. Mullahs, would your lordships be kind enough, Mullahs, to hear the states as well?
The states have already filed intervention applications.
Two states have, Mullah, but there's no notice gone to anybody. I mean, it's up to you, but I can only say.
We'll consider that. We'll consider that.
Because once it is in the concurrent list, Mullahs, then states can themselves legislate. This is something that your lordship should consider and hear the state.
What we'll do is let whoever is opening the case on behalf of the petitioners open the case. Let's have in about 15 minutes what is the nature of the canvas of the proceedings that they're going to urge. So we'll have to we'll form a better view after about, say, 15 minutes of their opening.
Yes, I have some more, something more to add, my lord. I adopt what the learned senior has said. Lord, the subject, your lordships are dealing with virtually, my lord, creation of a socio-legal system, socio-legal relationship of marriage, which, my lord, I'll come to, my lord, my preliminary objection would be, my lord, the domain of the competent legislature. When the subject is in the concurrent list, we cannot rule out the possibility of one state agreeing to it, another state legislating in favor of, another state legislative against it. But therefore, in absence of the states being not joined, my lord, the petition would not be maintainable. That's one of my preliminary objection. Lord, as I mentioned yesterday, Lord, I have also filed an application, my lord, requesting they decide a question which I have formulated as a preliminary question, my lord, essentially for this reason. A, Lord, the notices were issued in January, my lord. We didn't have an occasion, my lord, thereafter matter was never heard in merits, to raise the preliminary objection whether this court can at all go into this question, or it would be essentially for the parliament, my lord, to go into that question. Second, my lord, we also, my lord, would like to point out what would be the repercussions, my lord, if the court were to take it upon itself, my lord, in the judicial forum to take this call. The sum and substance of my application would be, if I were to say in one line, the debate which is to happen with respect to the subject matter of creating, conferring a sanctity, legal recognition of a socio-legal institution, should that be the forum of this honorable court or the forum of the honorable forum of the parliament?
Mr. Solicitor, two responses to that.
Lord, may I
just one second, Mr. Rohit. The nature of your preliminary objection and the tenability of your preliminary objection will really depend upon the canvas which they open up. And we say that with a due amount of reflection of mind on this. Let us see what is the canvas that they are opening up. Second, so that then we can consider your response. Second, what is really in the nature of a preliminary objection that you seek to raise is really your response to the petition on merit.
No, my lord.
So we'll hear you on that.
Lord, I'm sorry, my lordships may not preempt, my lord, my submissions on merit.
We'll hear you, of course. I mean, it can't be lost to our mind that what you're going to argue is that this is
obliged, my lord, your lordship will hear me, my lord.
That it's essentially in the domain.
Kindly allow me to clarify.
Kindly enter into it. So we'll hear you on that at a subsequent stage when you are responding to the arguments. Second, once we have some picture in the first 15 minutes or maybe half an hour on what is the canvas they are arguing, we may have a response to them on what is the canvas that we want to open up in this matter. But that's after we hear them, because
Lord, may I say, let me make my submission.
To tell them that, well, this is what we want to be, which we want to go into, would be really to preempt their submissions on what they want us to go into it. For all probability, for instance, they may say that this is so far and no further.
Personal law, there are also issues of personal law, adoption, succession, several issues that arise out of this, Mullahs. And that's the canvas that your lordship should be looking at.
Only one more thing. I'm after my lord, Mr. Sibyl comes.
This is the canvas. We want to view how it is being opened up.
Yes.
And whether it's the whole canvas to be opened up, not to be.
That's correct. That's
yeah. They're not that we are not.
No, your lordship. I'm just below the caveat that I'm just putting.
You're right. Yes, you're right.
There are other very complex issues Whether your lordships would like to go into that, not go into that, once we know, then we'll be able to
Exactly.
address your lordships.
That's exactly what we thought that's present to our minds.
Can I conclude, my lord? Can I
Yeah.
complete my request?
Yeah.
My lord, I'm sorry, my lord, my lords, slightly, my lord, preempted my request. First of all, I'm making it very clear. My preliminary my lord, objections are not my objections on the merits. If merits were to be gone into, there are separate set of arguments. These are not, my lord, these are only for deciding which forum would adjudicate upon and which forum would be the suitable forum and constitutionally the only permissible forum where this debate can take place. So by the very nature of the objection, it must, in my respectful submission, be heard first. While arguing my preliminary objection, I'll not raise any submissions on the merits of the case. I'm, my lord, very, very clear about it. And, my lord, therefore, my lord, your
So,
lordship,
Mr. Solicitor, we'll reserve, whether to hear you on the preliminary objection at this stage after they have opened up, just for about 15 to 20
my lord,
minutes. So that then we can-
then your lordships may do one thing, my lord. That's the another request. My lord, let them give, my lord, their, my lord, suggest whatever submissions they want, overview, confined to, my lord, what my preliminary objection is. My lord, I can't be
That we will
non-suit.
certainly not. We'll not do
I have to
anything.
open my case.
My lord, I'm sorry, my lord. My lord, I'm sorry.
I'm sorry, Mr. Solicitor. We are in charge. We will hear Mr.
I have
I'm
to
sorry,
open
my lord.
my
Kindly
case.
last minute, my lord,
Let me
last.
Mr. Solicitor, we'll hear you later.
Yeah.
Yes, Mr.
My
Roy.
lord, only a minute, my lord, only a minute.
No.
My lord, your lordships may give me a minute.
Dictate to us how we will conduct the proceedings.
No, I'm not, my lord. I am
I'm not
earnestly
allowed that
requesting.
in my court.
My lord, I am earnestly request. I would never do that. Your lordship knows, my lord.
Yes.
My lord, this is a matter, my lord, too sensitive an issue,
Of
where,
course,
my lord,
yeah.
your lordships would examine the preliminary submissions and, my lord, then give me some time. We may have to consider what would be the stand of the government, my
Certainly.
lord, in further participation in this debate.
So trust us to have a broader perspective of everything.
My lord, I fully trust, my lord. There is no question
Therefore,
of
we are
lack
just-
of trust.
We want to understand from them what they want to argue.
My lord, then, my lord, your lordships may give me time, my lord, to consider to what extent the government would like to participate in this.
Anything but adjournment, and I think anything but an adjournment.
No, I understand, my lord, your lordship's anxiety, my lord, I understand. I share that.
So, sir, are you saying that you don't want to participate? No,
Lord,
very
my lord,
strange
I am
way. If
only
you want to
saying,
participate, it's a prerogative you have.
my lord, I'll not
But
go
they
that
can
far, my
do-
lord.
No, Mr. Listen, that, let me say that. They look nice. When you say that we will see whether we participate or not.
No, my lord, I'll take instructions. I didn't say I'll not participate.
Instructions are here with this constitution.
My lord, the instructions on the question whether which forum should debate and discuss this subject.
It's a very important situation itself. That's the main this thing, whether the court can go into it or whether only parliament will legislation issue like this.
Lord, your lordships would examine, Lord, kindly give me 2 more minutes. Lord, this is not an issue which can be debated, Lord, by 5 individuals very learned on that side, 5 individuals on this side, 5 very brilliant minds on the court, no doubt about it. None of us knows what are the views of, my lord, a farmer in South India, a businessman in, my lord, Northeast. Lord, these will have to be, my lord, this will have social and other ramifications. My lord.
Yes, of course. We'll consider that. We'll certainly have that in
My lord,
mind.
your lordships, I'm sure would consider the request. Only request is kindly consider that first.
No, we'll allow them to open the case so that we have
My lord,
an
then your
idea on
lordships
what they
may,
are.
my lord, rule on that.
may-
That's my prayer, my lord.
May
That's
I
my
submit,
prayer.
Lord?
Yes.
A short preface first.
Statement of state, my lord,
Yes.
on behalf of state of Madhya Pradesh, which your lordship was kind enough to direct it.
Sir,
We
we'll
come-
hear you. There's no
So it's
difference.
not
Your
for
Lordship may hear any
intervention, my lord.
state. We have no objection. Your Lordship may hear any state.
No, not
Just as a
intervention, I'm
preface,
You know, you should have
everything which
joined
the
every state
solicitor
as
has
a.
said does not, my lord, hinge on maintainability of a petition under 32 by an individual who complains that his fundamental rights are being restricted in some form. I have a right to approach this court. This will be a defense, whether your lordship will leave it to the legislative forum or the courts forum. There is no question of saying, my lord, that I should answer that first. I will open my case. They will raise a defense. Please don't touch it. Throw it away. Your lordship do it all the time. Matter of executive policy, we won't touch it. He will say whatever he has to say. But I have a right to file a 32. I have a right to be heard. My grievance may be right, may be wrong. Your lordship will deal with it. And your lordship will deal with their responses about, my lord, this, that, or the other when it comes. It's not a case of 7-11. that, my lord, a suit is barred by operation of law. That is a preliminary objection. This can't be a preliminary objection that your 32 is there, but the impact of 32 will be this or that.
No, it's
That impact
maintainability
can
is
never be a part,
preliminary
my lord,
objection.
of a preliminary objection. That be a defense. That don't touch it. This is too overbroad. This, that. They will say all that, my lord. So now, my lord, let me open my case.
Yes.
Yes.
Well, only one aspect, my lord, and
Please now.
Yes.
ultimately
Allow
it's
us
a
to
lordship
open.
prerogative. But I should not, my lord, be, my lord, told after, my lord, generations after generation, we did not bring this to a lordship's notice. In Special Marriage Act as well as in Hindu Marriage Act, every state have separate rules.
Please.
That makes more, my lord, case for calling all the states and hearing them. Your
My lord,
lordships have, my lord,
My lord,
partial view from both sides.
Only one.
He
My lord,
is very clear about his view. I may be very clear about my view, but none of us represents views of the nation.
my lord,
That's my preliminary
Your-
objective.
my lord, the Solicitor General is aware of all the persons that we are talking of fundamental rights. Fundamental rights, by their very nature, are a limitation on the legislative power of the state. Your lordship need not defer to
I'm
Parliament.
not for a
it's
second
now-
saying
If it is a fundamental
is
right,
not
my lord,
there.
and if it
Who
is,
should protect the fundamental
it is
rights?
a
Whether by
status-
parliamentary law?
All right. What
or
we
by-
do is,
Can I- let us
fair
start,
enough.
fellas.
my lord, if it is a status confined to,
We'd like
me
to
open my case.
Yes, you can tell us.
Yes,
about
let me
15
open my
What
case.
is the canvas of the case?
So, my lord, in a very, very narrow conspectus, my lord, we are persons, my lord, who are of the same sex. We have, my lord, according to us, the same rights under the Constitution as the heterosexual group of the society. Your lordships have held so. I don't need to reinvent the wheel. That we have exactly the same rights as our brethren of the heterosexual group of society, which is the majority. We are a minority. Lord, the only stumbling block on our equal rights, equal opportunities, equal dignity, equal, my lord, fraternity was, my lord, 377. By virtue of 377, our actions were subject to criminality. Because it was criminality, my lord, it could not be equal in all measures of the heterosexual group. Criminality is now gone. The unnatural part or the order of nature under 377 is now effaced from our statute book. And therefore, our rights being equal in all forms, which are, my lord, reflected from Puttu Swami, Navtej, my lord, the judgments of this court on the right to marry a person of your own choice, Shafeen and all that, which I will show. If our rights are identical as held by the state, then we want to enjoy the full panoply of our rights under 14, 15, 19 and 21 to lead a dignified life, not mere existence like your lordship said in Francis Corali Bulin 40 years ago. To lead a life to our fullest extent with dignity, privacy in our home, and, my lord, without taint or stigma in public places. And therefore, we cherish and desire the same institution between two people as is available to the others, which is, my lord, the concept of marriage, the concept of family, because marriage and family is respected in our society. We don't, my lord, today, my lord, laws have now, my lord, progressed. In the Domestic Violence Act, even live-ins, my lord, are allowed. That is recognized by the court. Your lordship recognize it by even giving, my lord, property, money, inheritance, etc. So there is no reason why, once our rights are identical and same as held by your lordships, my lord. And that has been the development, my lord, in the US and other nations. I have made a one-page chart which I'll show to your lordship. Therefore, my lord, we seek a declaration, because we have to be concrete. What do we want from the court? We seek a declaration that we have a right to, my lord, get married. That right, my lord, will be recognized by the state and would be registrable under the Special Marriage Act and other acts. But as far as I am concerned, my lord, my brief is to say that we want a declaration that we have a right to marriage and that marriage will be recognized by the state by virtue of the imprimatur of this court. And once that happens, the society will recognize us. Because even after 377, my lord, there is a stigma. If two people walk hand in hand in a park, my lord, or in a hotel or in a mall, they are still stigmatized in public. That stigma will only go after the imprimatur of this court that they are entitled to get married, and the state shall recognize it. And once the state recognizes it, it can also be registered. And that will be full and final assimilation of this minuscule group, my lord, into
Now, Mr. Rohde, assuming that you seek a declaration from the court
yes,
that queer people belonging to the queer community,
yes,
same-sex couples,
have a right to
have a right to marry, and therefore the state must recognize the
My
marriage
lord.
between these two. Now, what is the next step? Are you therefore saying that the Special Marriage Act already recognizes that right inherent in it?
Well,
a matter
my
of
lord,
an interpretative device or an
by an
interpretative
interpretive, my lord, I don't want it to be quashed or anything.
Right.
By an interpretative device, in one line, if I was to say, the provisions, my lord, of the Special Marriage Act made in 1954. Today, my lord, we are now 70 years down. There is a lot of evolution. As I said, my lord, livings, etc., have now come in. I want to say, my lord, that your lordships will broadly read spouse in place of man and women, or husband and wife. And that is it. And if I may show, my lord, a classic example of the definition of marriage in Black's dictionary, which I will show to your lordship, in 1968, said, my lord, it's a union of a man and woman. But when the definition came in 2019, it says, my lord, a union of two persons. So concept of marriage has changed over last 100, 200 years. We had concepts of, my lord, group marriages. We had very different concepts. We had concepts of child marriage. We had concepts of, my lord, temporary marriages. We had concept that, my lord, prior to the Hindu Code Bill introduced after by Pandit Nehru, my lord, in 1950, a person could marry any number of times. That, my lord, also changed. Hindu Code Bill, my lord, was not accepted. There were a lot of protests to this new avatar of the Hindu Marriage Act. It was not accepted. And Dr. Ambedkar had to resign. Then came the evolution of Hindu Marriage Act. Now in Hindu Marriage Act itself, my lord, in 2005, the rights which were restricted of women, starting from the Women's Right to Inheritance Property Act in 1937, all that has now changed, my lord. And full rights are available in 2005. So, my lord, Constitution is a living document. The preamble says, my lord, equality, fraternity. And I will read passages of, my lord, the Chief Justice, my lord, judgment, my lord, in Navtej, in Puttaswamy, in Shafin, in Deepika, and Justice Kaul, my lord, also referring to it. This is the thread. If this is the thread of the Constitution, equality, fraternity, justice to all, today we are a part of the all. The only thing which was stumbling, my lord, was that criminality. That is now gone. If we are a part of all.
So really, your analysis is two-step. One, the declaration of marriage as a fundamental right as being implicit in the constitutional guarantees 14, 19, and 21.
No, as interpreted by lordships, my lord, in Puttaswamy, Navtej, basically.
And then step two, the second limb of your submission, that this also can find recognition by a reading, an appropriate reading of the Special Marriage Act.
My lord.
So you're not going into the broader issue of personal law and other things, we take it. Right?
No, my lord, I am not.
Right.
And I am not also touching any personal law of Muslims, etc., my lord. Somebody may raise an issue, I am not. Hindu Marriage Act, yes, but basic first will be Special Marriage Act. And your lordship knows, my lord, a legislative tool in the Indian legislative devices has always been that a definition clause always starts with, my lord, your lordships are aware, unless the context otherwise requires. That is the elasticity given to every legislation, more or less, in this country by Parliament, that you have to, my lord, adopt or adapt to 20, 30, 50, 70 years later. Can't keep changing the law, can't keep changing definitions. So you have, unless the context otherwise requires. So if the context requires that a man and a woman or a husband and wife to be treated as persons or spouses, your lordship will do it by an interpretative tool, number one. Number two, this question, that whether, my lord, the court should wait for the legislature to act. Firstly, it arose, my lord, in Navtej. The court, my lord, entertained rather than waiting for the government to, my lord, remove it or not remove it. But there is, my lord, authority for the proposition. in Milord Navtej, Shaira Banu, Puttuswamy, that the court need not wait for legislative, Milord, interference. And if it is brought to the court's notice that my fundamental right is being restricted, Milord, by the state or by this society because of its mindset, which has to now open up, the court's duty is to act. That is, Milord, clearly laid down. Milord, our lives are passing by. We are getting older. We also want to have the respectability of a marriage, respectability of a couple. What is the point of saying that only criminality in your bedroom is removed? But, Milord, when you go out, there is a passage of Justice Chandrachud, Milord, in one of those judgments, that what matters is what happens in a public space. What is the concrete position? If today, Milord, what is the position? All right, 377 is gone. But if these people, call them queer, call them strange, people call them all different names. If they were to go to different places, people look at them. Look, they are going this way, they are going that way, they are doing this, they are doing that. That, Milord, that is a restriction or an infringement of my right, which is Article 21, to, Milord, live with dignity, freedom, privacy, full expression of thought under 19(1)(a), no discrimination under 14, and, Milord, in 15, as the Lordship knows, there will be no discrimination only on the ground of sex, caste, creed, etc. And only on the ground of sex, Lordship judgment, Justice Chandrachud, talking about Nargesh Mirza, that Air India case, and, Milord, that Anuj Garg, that, Milord, the Delhi hotels case where, Milord, women could not, Milord, become employees. So your Lordships have accepted Anuj Garg, which is an expensive definition of sex to mean sexual orientation. Sex does not mean, Milord, only male, female. And your Lordships have, Milord, discounted the verdict in Nargesh, clearly. So Anuj Garg has been accepted by His Lordship Justice Chandrachud in that judgment, and also, Milord, in Nalsa, where we're dealing with transgenders, there are passage after passage that if you have to give them equality, that equality, Milord, also must reflect positively. So you have the negative part, don't discriminate. There is a positive part in 14 and 15, affirmative action also. Milord, sorry to say that Nalsa said that give them reservation. Years ago, nothing is done. Years ago. Your Lordship judgment, Milord, in Navtej, give full publicity. Today I read in the Indian Express, today, your Lordship judgment says give full publicity. People must know that it's not a criminal offense. Don't look at them with this stigma. Milord, years ago that judgment was delivered. Nothing done. And the three ministries today say, we have not done anything and we are not supposed to do anything. If this is the state of affairs of legislative, Milord, interference or legislative response to judgments of this court, I have no choice but to knock at the doors of this court and say, Milord, I have a sense of deja vu. I was here. I opened the case on 377 years ago, before 5 judges, 5 years ago, in this court. This is how, Milord, we reach step 1. And there is a passage in Justice Chandrachud's, Milord, verdict, which I will show, Milord, that this was the first step. That is that sense. This was the first step. Remove that obstacle. Bring them up to the mark with the others. They will walk, Milord, shoulder to shoulder. The Constitution said secular. What is secular? Regardless of caste, creed, color, sexual orientation, full expression. So we are a part of one homogeneous whole, but with the similarities of caste, creed, color, religion. But everybody is entitled in our secular polity, a pluralistic society. Justice Abarwal, Milord, in Coelho, secularism is a part of basic structure. Equality is a part of basic structure. If they are a part of basic structure and a part of the triangle, Milord, I would say quadrangle, not triangle, 14, 15, 19 and 21. If they are a part of that which are inalienable, part of the basic structure, cannot be removed by anybody, cannot be tinkered by anybody, as understood by your Lordships. I am not reinventing the wheel. Whatever I am saying, Milord, is actually a paraphrase of what I have read in the last couple of days from those judgments. And I will show you some passages. I am only going to put the pieces together, Milord. And I have, Milord, for a Lordship's, Milord, convenience, Justice Bhatt might recall, my lord, in that reservation case, I had made a big chart to show you how the judgments went, my lord, in reservation. Here I have made, my lord, your lordship found it, my lord, useful. Here I have, just hold on, dude. I have made, my lord, a one-page chart. Starts, my lord, with, my lord, 1860, the penal code.